The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. The first case is 20-6163, in re Precious Latricia Oliphant.
Ms. Baldwin, are you there?
I am, Your Honor.
And you represent Ms. Oliphant?
I do.
We're pleased to have you, and you may proceed.
Thank you. Good afternoon, Your Honors. Melissa Baldwin on behalf of Precious Oliphant. We are asking this court to reverse Ms. Oliphant's summary contempt conviction for saying a 3-word profanity on her way out of the courtroom when nothing was occurring at the bench. The contempt conviction here suffers from 3 errors. First, the conviction is predicated on a single isolated profanity not directed at the court, which presents a problem under the Supreme Court's case in Eaton.
Ms. Baldwin, as to that point, and I agree with you, that's a significant issue in the case. If Ms. Oliphant's comment was not directed to the magistrate judge, who was it directed to?
Well, we simply don't know who, if anyone, it was directed at. I mean, the magistrate judge made no finding that it was directed at the court, and due process prevents this court from making it in the first instance. And moreover, the record contains, it's subject to reasonable dispute who, if anyone, it was directed at. Perhaps it was directed at the defendant, Mr. Williams, for getting himself in the situation where he's going to prison for 15 years. Perhaps it was directed at the co-defendant who got Mr. Williams into the situation in the first place. Perhaps it was the defense counsel who misrepresented to Ms. Oliphant how much time Mr. Williams was looking at. Perhaps it was directed at the court, perhaps another courtroom spectator. We simply don't know. And because we don't know, this court is limited to affirming it on the basis that the magistrate found. And in this case, it was simply the use of a single isolated profanity. And as explained—
Let me ask you this. The district judge did— well, I think we're going to ask the same question. The district judge did make a finding that the outburst was directed to the magistrate judge. Can we rely on that?
No, you cannot. And so this was pretty directly addressed by the 11th Circuit in the Matthews case, where the judge who witnessed the misbehavior has to be the one certifying the facts. And so in Matthews, it was a visiting judge, and the chief judge in that district reviewed the transcript and said, okay, I know what the contempt is. And the 11th Circuit said, no, you cannot do that. It must come from the observing judge. So you can't rely on the district judge's finding. And in fact, the district judge should have never made that finding in the first place.
Ms. Baldwin, so if the magistrate judge had made that finding, you might have a different argument about the sufficiency of the evidence to support it, right? But your point is that the magistrate judge, as the finder of fact, was the only person who could make that finding, and it had to do it as part of the contempt proceeding. Is that right?
Correct. If the magistrate judge had made the finding it was directed at the court, we wouldn't be raising an Eaton claim here. We would likely be raising perhaps a sufficiency claim on the obstruction and intent points, and certainly the abuse in the summary procedure, because that would track exactly what happened in the First Circuit case Brown, where the judge found a profanity uttered on the way out of the courtroom was directed at the judge, but the First Circuit was concerned with that finding and said it was an abuse of discretion not to give that person an opportunity to defend themselves.
So can I ask you about that? What exactly is the process that you envision, or what does the law require in terms of a summary contempt proceeding in your mind, and what was missing here?
Certainly. And so I would direct the court to the Second Circuit decision in Dorel Produce, and I think they do a good job. They rely heavily on Judge Friendly's dissent in a prior case, where just because it's summary, that dispenses with the normal procedural protection, but that doesn't mean you take away someone's basic opportunity to speak in their defense. And so that's all we're asking for here. It would be very limited to the fact.
Well, I mean, I don't think it's fair to say that the court did not give your client an opportunity to speak. I suppose your argument is that she had absolutely no clue what the heck was going on. She was hauled up in front of the judge, and she was told that she had uttered an expletive and that the court had heard it, and there's the presence of the court, and that the court was going to proceed to contempt. But that's it. And I guess your point is that's not enough?
Well, my point is there are 2 points addressed in that, and the fact she had no notice and was just kind of hauled in, that goes to the ordinary review and Rule 51 provision, but the opportunity to speak is separate, and that goes to a meaningful opportunity to speak in her defense. And so in Dorel Produce there, the court found the person in contempt and then said, do you want to say anything? And the Second Circuit said that's not a meaningful opportunity to speak in your defense, because at that point, the court's already found you in contempt. What good is it to say like, well, no, I didn't do that? So you have to give someone a meaningful opportunity to speak. And regardless of the parameters, it certainly wasn't the case here, where Ms. Oliphant wasn't given any opportunity to defend herself before she was held in contempt. Indeed, the magistrate
You're
judge—
saying she should have been given some kind of a notice. What's the notice that you're talking about?
Oh, sure. So the notice for the opportunity to speak would be simply saying like, Ms. Oliphant, there is a provision that prohibits misbehavior that obstructs the administration of justice. I heard you say piece of SHIT as you were going out the courtroom. Do you have anything to say for yourself before I decide whether or not you committed that attempt? Done. It's very short, and it wouldn't be a burden, and it could get rid of some of the problems we're facing here. And especially like this woman ended up spending 13 days in jail for this. So the opportunity to clear up any confusion or address this—
saying she could have? Do you say she should have been given a lawyer?
No, I'm not.
You don't say that. Now, they cite Ms. Ray filed a 28J letter, and the government relies on I think it's Morello or something like that, the opinion that recently that Judge Floyd wrote, and I was on the panel, I think. Do you think that Morello case helps him or you?
To the extent it has any bearing, it's
Not
certainly—
that him. Does it help? Does it help the magistrate judge, or does it help? Who's it favor? The Morello case.
It favors us, and that's because there was evidence. So there, the immigration judge specifically testified that it was visually disruptive. So again, that's the finding missing here, going to the obstruction element. There was also, in addition, there was a warning here. There were multiple warnings given to that attorney in the immigration proceeding. There was both a posting—
That's Morello. She was given warning.
Oh yes, there was
But I thought you would first thing you would say, well, that was not a summary proceeding. That was not a summary.
No, it wasn't a summary proceeding.
She had a trial.
Right. Yes. No, it was a trial, but that the warning goes to show that the court has other ways of dealing with it. So having a district judge give a warning, that kind of conduct isn't tolerated. If it happens again, you're going to be in contempt. That is something that can easily be accommodated to both ensure the rights and justice for people in the courtroom and the court's ability to maintain decorum. And I'd
Ms.
like
Baldwin, just to be clear though, a warning is not absolutely required. I think if in this case, if Ms. Oliphant, if it had been clear that Ms. Oliphant had directed the expletive at the court and the court had made a finding to that effect, warning or no, I would think that would be grounds for contempt. Do you agree?
Yes, and so profane insults to the judiciary are a kind of a separate subsect of contempt, and we don't question those line of cases. Our argument is they don't apply here. I'd like to just move on to the insufficient evidence, because even putting aside the Eaton problem here, this conviction isn't supported.
That's your second point, insufficient evidence?
Yes. There is not substantial evidence here to support the contempt conviction on two elements of the contempt. First is Ms. Oliphant's wrongful intent. So intent is a requirement to convict someone of contempt. And here, the magistrate judge made no findings whatsoever on intent. And again, this court can't go outside and make its own findings, especially where the record is subject to differing interpretations. For example, the government claims the fact that Ms. Oliphant was on her way out of the courtroom suggests she was trying to escape culpability, versus an alternative and plausible, reasonable explanation is that Ms. Oliphant, waited until the proceeding was over. The court wasn't doing anything to not show disrespect for the court.
Ms. Baldwin,
Let
is
me
the
ask you
nature of
this.
go ahead, Judge.
Go ahead,
Floyd.
Judge. Let me ask you this. You did use the word reasonable. This triggered in my mind. Do you think he should have made a finding that she was guilty of criminal contempt beyond a reasonable doubt?
Yes. Well, I mean, I think that's something that the fact he convicted her of contempt, I would say necessarily meant beyond a reasonable doubt, but to convict someone of contempt, you have to, it has to be guilt beyond a reasonable doubt.
Ms. Baldwin, just to follow up on that, so understanding that Ms. Freeman is not a lawyer, and earlier on you were talking about the myriad possibilities that the expletive might have meant in the context of these proceedings, but as I understand it, this was a case where the parties had agreed on a sentence, right? So there was no dispute about what was going to be happening to the criminal defendant in this case, her boyfriend. And there was nothing out of the ordinary that I could tell from the proceeding that would have resulted in a reasonable observer having been upset at what the judge had been doing. So if we're going to speculate, it seems to me that the speculation cuts against the government's claim that the expletive was actually directed at the court, given the context of the hearing and the fact that, at least from what I can tell from the cold record, there's nothing to suggest that the judge did anything that would have drawn the ire of anyone in that courtroom.
I completely agree, Judge Diaz. I mean, when I first heard that, my first thought was she was referring to her boyfriend or the co-defendant, the people that engaged in the crime that led to the situation. So I agree with that point, and that's just to, again, supports the insufficient evidence. And I'd like to move on to obstruction here, because there is a little dispute as to whether or not our argument that the contempt adjudication itself can't be subsumed into the obstruction element, whether or not this panel is free to reach that issue. And indeed they are. Warlock dealt with, both Warlock and People dealt with non-summary contempt. So there was no suggestion that the judicial investigation occurred independently of the contempt adjudication. So here, that is squarely presented, and it is what the Oberhelman Seventh Circuit Court was concerned about, where if the contempt adjudication can supply the obstruction, that will write the element out of the statute. And so there has to be something aside from the contempt adjudication that delayed or made costs to the court. And here, again, the Rule 42 certification doesn't tell us anything about what effect Miss Oliphant's three-word profanity had on the courtroom administration.
Was there an ongoing proceeding at the time of this utterance?
No. The court was active. Judge Kerr was on the bench, but there was no proceeding occurring. If you look at the transcripts, the Rule 11 proceeding concluded at 10:40 a.m. without incident. The profane remark occurred at 10:40 a.m. and the summary contempt adjudication was completed at 10:42 a.m.
Is there an indication in the record of what the next proceeding was, or if there was one?
There was another proceeding. I know that happened. I'm not sure I know for sure it was, because I contacted the court reporter about.
But does the record show? I'm talking about what the record before us.
I don't think there's anything in the docket report or that was in the transcribed hearings. So no.
So you're saying there's nothing to obstruct?
Right.
Is that what
There was nothing. I'm sorry.
No, go ahead.
There was nothing to obstruct, and so that's part of why this is, you know, materially different. We are definitely sympathetic to the struggles lower court judges have sometimes with, you know, containing everyone, ensuring justice can be done. But this is not the situation. Certainly, if there was a profane remark when the judge was giving jury instructions or advising a defendant of their rights, that would be a different situation. And we're in no way, you know, suggesting that reversing Ms. Oliphant's contempt conviction will tie a judge's hands to deal with those, you know, more egregious situations, emergencies, or just more clear acts of contempt. And so my final point is the summary procedure, and it was, you know, unnecessary and excessively summary. So we've already touched a little bit about the lack of an opportunity to speak on one's behalf. And so that's not something that the Supreme Court or this court's precedent currently requires, but the Second Circuit has required it, and the First Circuit in a similar situation, basically where it wouldn't be unreasonable to do so, and it would be helpful. It is an appropriate opportunity for the judge to give. And again, there was no immediate penal vindication here. The judge had other options to deal with Ms. Oliphant's behavior, such as a public reprimand or a warning that additional conduct. I'm sorry, may I finish my thought?
You go right ahead, and to the extent you have questions, you better just stay with us. Yeah.
Of course, yes, Your Honor. Okay. So, and could have given a warning, and she would have been held in contempt if they violated it. And so for these reasons, the conviction both runs afoul of Eaton, is unsupported by substantial evidence, and the summary procedure that procured it was an abuse of discretion. So the conviction should be reversed.
I have a question or two yet. Now, the following day, or at least within the 24 hours or so, somebody asked for counsel for this lady after she'd been put in jail, and counsel was appointed, but then there's an indication that the public defender didn't know about it for 5 days. What's the reason for that?
It's certainly not on the record, and honestly, our office doesn't know. All we know is, you know, there was this 5-day delay between, you know, the court agreeing to appoint her counsel and that being transferred to our office to appoint her counsel. So unfortunately, I don't have much more explanation for the court.
And then there was a delay. She had a 10-day sentence, and she served 13. How did she end up serving 3 extra days?
The marshals mixed it up, didn't release her, and just released her on the 13th as opposed to the 10th day. You know, by the time we found out, she was already out, so we weren't able to assist in that.
And I heard you say you want a reversal. Is there an alternative relief of a trial at this point, or is that kind of moot?
So if it's unsupported by insufficient evidence or runs afoul of Eaton, then the only remedy for those errors would be reversal. The issues with the summary procedure itself, you could remand it. We're asking that you not do it, and we rely.
I understand that you're doing exactly right for your client, but I'm asking you if there's an alternative if we don't agree with you on everything about the summary reversal.
Right.
Is there a basis for vacating and then giving the lady a trial?
So I believe the issue that you could do that if you rejected our Eaton and insufficient evidency, but found our summary procedure argument meritorious. A remedy that has been there is to vacate the conviction and remand it. So for example, if you found the summary procedure was unnecessary, you could order it remanded to comport with the non-summary procedure.
Mm-hmm. And would her counsel stay with her, or would she be without counsel for this trial?
I believe she'd be with counsel if it was a
With counsel. Now, would the trial be before the same judge, or would there be a different judge?
I believe it would be before the same judge. The judge only has to recuse essentially if it's if he's embroiled in the controversy. So I guess to the extent maybe if there's the utterance was directed at him, there may be a question as to whether or not Judge Kerr should preside. But on this record, I can't. I think maybe he'd preside, but leave open the possibility there could be a problem.
I'll tell you all before you sit down there, I'll give you a lead to look at for that last question. There's a case called In re Richard Nell, N-E-L-L, 1971 opinion, published opinion of the Fourth Circuit, authored by Judge Hainsworth.
Mm-hmm.
You might look at that on that as next to that last question. That's all I have. I'm sorry, Judge Diaz, Judge Floyd, you have questions? Go ahead.
I do not. Thank you, Judge King.
I don't either, Judge King.
Thank you very much, Ms. Baldwin. And you'll say you've got some rebuttal time still. Ms. Ray, good to have you with us.
Thank you so much, Your Honor. May it please the court, Amy Ray for the United States. Your Honors, the Judge Kerr properly exercised his summary contempt authority, and a couple of things I want to note right off the bat, right at the beginning is, one, this court has made very clear that if a defendant or a person in a courtroom engages in conduct that is disrespectful or sufficiently disruptive, then the court may exercise its summary contempt authority, and that means no notice and no hearing. That's part of the summary contempt proceeding. So in this case, Judge Kerr gave...
I'll say about that, Ms. Ray. I was impressed with the fact that his name's on our building down there in Richmond, and he's quoted in one of these briefs about, and that was it at the Eaton case back in the early 70s.
So, Your Honor, the Eaton case, the reason that the Eaton case is not helpful to Ms. Oliphant is that in Eaton, this court said that a single expletive or profane language does not warrant summary contempt, but the court noted that there was no allegation in that case that the utterance of that profanity had been loud or boisterous. And also, it was clear in the context of that case where the word was chicken shit, if you may, was talking about an assailant on cross-examination. This is very different because this isn't simply a word uttered without loud. I mean, Judge Kerr found that she shouted it in a loud and angry tone as she was walking out. This is not the same thing as any of the cases that Ms. Baldwin has cited, because every single one of those cases is not a loud and angry tone shouted out in the middle of a courtroom. It doesn't matter whether this was directed at the magistrate judge or at the defendant, or more frighteningly, perhaps, at one of the spectators. In other words, what we know about this language
Ms.
that
Ray,
was
can
used
Ms. Ray, I'm sorry, Judge Diaz here. Let me just read you a couple of sentences from Eaton. The court there said, a single isolated use of street vernacular, not directed at the judge or any officer of the court. So that's the first problem you have, is that even though you're making an inference, or at least the district court made an inference and you support that inference, there was no finding by Judge Kerr that it was actually directed at him or any officer of the court. And then the court went on to say, cannot constitutionally support the conviction of criminal contempt. And then it said, the vehemence of the language used is not alone the measure of the power to punish for contempt. So that seems to address the first part of your argument, that the vehemence and loudness of the profanity. So I'm having a hard time distinguishing Eaton in this context, and particularly since there's no finding in the record as to who that expletive was directed at?
So, Judge Diaz, I would respectfully say that when the court says vehemence of the language, that means the word itself, right? That this word contains power. In that case, it was chicken. That word contains power. But what the court noted and was very clear about in Eaton was that there was no allegation that it was loud or boisterous. Those allegations not only exist in this case, that was a finding made by the magistrate judge. It was loud. It was angry. She shouted it.
Okay, so you're suggesting that a single loud profanity warrants a 10-day prison sentence that ended up being 13 days in jail. Is that what you're saying?
I am saying that a loud, profane remark uttered at someone in the courtroom, there has to be an object to piece of shit, right? There's an object to that. She's calling someone or something a piece of shit. And I'm sorry for the bad language. I'm not sure how else to do this.
Okay, well, the witness in Eaton was directing the language at the defendant, right? Calling him a chicken shit.
On cross-examination, that's very different from someone leaving the courtroom and yelling it. And that is a distinction the Supreme Court itself made. There was no allegation in that case that it was loud or it was boisterous. Now, we can ask ourselves whether or not the length of the sentence was appropriate, but the defendant's not actually challenging that. She's not saying the judge didn't have authority to sentence Ms. Oliphant to 10 days.
Okay, let me just so that I'm clear, Ms. Ray, about your position in this case.
Sure.
It doesn't rise or fall on whether or not we make the inference as to whom it was directed?
Not at all. I would say that when somebody calls somebody in the courtroom by that word and calls them that name, then it's just as harmful to the orderly conduct of the administration of justice, whether it is calling a magistrate judge, the court security officer, a litigant, or a spectator. It doesn't matter to whom it was directed. You're saying
it's someone. It was directed at someone. Maybe it was right. Just the whole proceeding. I don't know.
Well, if it was the whole,
do we know on the basis of this record? Well,
Your Honor, if it was the whole proceeding, I mean,
we know there were 3 words, and they're 3 short words.
Yes. Right.
And
well, three
we
short,
know that
profane
proceeding that lasted 2 minutes, and we know that this lady went to jail. And
right.
Did the judge know anything else about this this lady that's not in the record? Did he know whether she was employed or whether she was a girlfriend? I mean, that's not in what he said, I don't think. Whether
it is actually. Yeah, sorry to interrupt you, Your Honor. Go ahead. I'm sorry.
Did he know anything else? Did he know whether she had children at home or whether she worked or how old she was?
Yeah.
Or anything before he put her in jail?
No. So what we know is that he asked her on whose behalf she was before he found her in contempt. He basically said, what are what's your involvement here? Who are you here for? And she said, I'm here on behalf of the defendant.
I think he said, are you here on behalf of the defendant, didn't he?
Pardon? No, she said that. I'm here. She said, I'm here on behalf of the defendant. And those are her words.
No, the court said, are you here on behalf of the defendant? He's the one that raised defendant. He didn't.
He did, and but then she says, and I'll quote it, yes, on behalf of the defendant.
Go back 3 lines. And
he did suggest it.
Are you here on behalf of the defendant? But she doesn't say that she's the defendant's girlfriend.
Absolutely correct. And she doesn't say that. And he does ask, "Are you here on behalf of the defendant? What's your involvement?" And she says, "Yes, on behalf of." Who was it
that called her his girlfriend?
We only know that on appeal. We don't. That's not something that was in the record at the time that Judge Kerr held her in summary contempt. But I want to make the point that the whole purpose of summary contempt is to regain control of a courtroom or to respond to something that happens in the courtroom that is disrespectful of the solemnity and the place of the courtroom. So it is, the whole purpose of it is to be able to do it quickly, and you take care of it right away so that it discourages anyone from engaging in that kind of behavior again. And this court can, and lots of courts have recognized, and I would refer the court, for example, to the District of Columbia's In Re Sealed case, that the use of profanity in a courtroom directed at someone, in that case the court, but I would respectfully suggest that I don't know why directing profanity at a court is any worse than directing it at a spectator or a litigant, if it is loud and angry, which was not the case in Eaton. The purpose of the summary contempt proceeding is to be able to do that quickly, and it is fully authorized if it is not, there's no notice and no hearing. But Judge
So, Ms. Ray,
so
under your scenario, any defendant, potential contemnee who is very polite and speaks in a low voice, but issues just starts hurling invectives left and right, that's perfectly fine.
No, Your Honor, invectives left and right would not be. But a single expletive that was not direct, that was
what
not.
What about if Ms. Oliphant
had
said in a very respectful tone of voice, Judge Kerr, or just this is a piece of shit, had not yelled it?
Well, if she had done that, I don't think the court would have heard her, and I don't think we would be here.
What if the marshal? No, okay. What if the marshal, or someone in the gallery had heard it?
Yeah, then I don't think that if she just said this is a piece of shit, no, we wouldn't be here. I don't think, and if we were here, I don't think that it would be defensible under Eaton if it were not directed at a court. But what we have under Eaton is saying, if it's loud and boisterous, because the court in Eaton specifically noted that those allegations were not present. And here we have a loud expletive directed at someone. This is not, we may say son of a
Ms. Ray,
right?
I get that. I understand completely that this is not behavior that one would necessarily condone or would certainly would want to try to prevent. But the other thing that's important about this case is that she said it as she was on her way out the door. So it's not clear to me how she would have been disrupting any proceedings. So it seems like you're left with sort of the deterrence aspect of this. You don't want this to occur, and so you haul her back in and you hold her in contempt. Is that the objective here? Is that why you think that's appropriate?
Well, I guess two responses to that, Judge Diaz. The first is that what she did was sufficient to qualify as disrupting the court proceedings. Court was still in session.
What was the proceeding, though? What was the proceeding?
They were moving from one proceeding to the next, and this court in Peoples said specifically, we have held that the delay and distraction resulting from a court's investigation of misconduct can be considered in determining if a defendant has obstructed the administration of justice. So when he asked the marshal to go and get her, right then there's a delay in the movement and the transition from one court proceeding to the next. He was on the bench, court was in session. And even in Peoples, one of the points that the court made in Peoples was that the court security officer in that case had to go and respond. And that's exactly, and the court said in Peoples, even if the Seventh Circuit rule applied, which is that the obstructive act itself can't be the act that is the contempt can't itself provide the obstruction. Even if that were true, this court recognized in Peoples that where a court security officer has to respond, then that is enough, because that is more than simply the obstructive act, or the act that is the contempt. So I want to respond, Judge Diaz, by first saying that we don't concede at all that this did not obstruct proceedings, because they did. And when Ms. Baldwin says that it was over at the time because you can tell from the transcript, well, the transcript ends with her saying that's the end of the transcript. So then we go and start the next transcript that begins with those words. So there was an open court proceeding. And then the second point is that it isn't just deterrence, but this court and others have recognized that the demoralization of a court proceeding, that happens when someone expresses outrage in a public way, if it is a single expletive that is not spoken loudly or angrily, then, and it's not directed at the court, then Eaton tells us that's not enough. But what Eaton also tells us is that if it is in a loud and angry tone, if it interrupts that court proceeding, if the judge has to stop, if they ask the marshal to go get her, and now we have to open a new proceeding, that interferes with the orderly administration of justice. And the question is, did the court have the discretion to do this? So we've argued plain error, but even if plain error doesn't apply, this is an abuse of discretion standard of review. Did Judge Kerr actually abuse his discretion in exercising his summary contempt authority when on her way out of the courtroom, when presumably she would think she could get away with it? The defendant yells this at someone in that courtroom. And I would respectfully suggest that there's no abuse of discretion in invoking and in exercising his summary contempt authority. Then the question becomes, did he do it properly? Is there sufficient evidence? Well, he didn't have to provide notice or hearing.
How do we know, Ms. Ray, how do we know that it was directed at someone in the courtroom? Could it not have been directed at someone outside of the courtroom?
I don't think that there would be any reason. I mean, it's hard for me to imagine that it could be, but let's put it this way, Judge Diaz. No matter to whom it was actually directed, everyone in that courtroom had to wonder, who was that directed to? It stopped things. It was disruptive in a way that was harsh, angry, loud, and not something that a magistrate judge should not be able to respond to appropriately. And she's not challenging the 10-day sentence. She's challenging the sufficiency of the evidence. So let's go through the sufficiency of the evidence. Was there misbehavior? Yes. Did it occur in front of the magistrate judge? Did the judge witness it? Yes. Was it sufficiently disruptive that it interfered with the orderly administration of justice? I've already addressed that. Yes. And then the question is, would Ms. Oliphant have known or reasonably should have known that her conduct is wrongful? And while the magistrate judge did not make an explicit finding that she would know, multiple courts have recognized that when someone is that kind of an outburst, expletives in a courtroom, we all know when we go into a courtroom that that's not appropriate conduct, that conduct is wrongful. And so this court can uphold that. In fact, in the in re sealed case that I mentioned earlier from the D.C. Circuit, a 2010 case, the defendant, after the sentence was announced, it was all done, the defendant said, F y'all. Didn't say to whom that was directed. And the D.C. Circuit upheld it and said that was inherently disruptive and self-evidently intended to show contempt. So I would respectfully suggest that all of those elements are met here, and that the district court did not clearly err, and it is a clear error standard of review in terms of finding that the element of intent was satisfied. It did not clearly err, and all of those were satisfied, and he had the discretion to employ the summary contempt proceedings and properly did so.
Ms. Baldwin mentions and maybe you're getting to this, Ms. Ray, that the process itself was flawed because her client wasn't really given an opportunity to speak and defend herself against the charge. You want to address that?
Sure. Thank you, Judge Diaz. Summary contempt does not require a hearing. She didn't have to have any opportunity, but she did. He asked her who she was there for. She said, on behalf of the defendant. And then after he said, okay, I'm going to hold you in contempt, do you have anything else you want to say? That he gave her the opportunity to explain, and it's possible that had she explained, well, I didn't really mean, I wasn't talking about you, Your Honor, I wasn't talking about spectators, he may have gone back on his finding of contempt. But even if he didn't, she had the opportunity to request leniency. Neither of those things is required in a summary contempt proceeding, but he gave them to her. Now, I do want to address, Ms. Baldwin references the Brown case out of the First Circuit, saying that, all of these cases say if a judge, it's a good idea to provide more rather than less process, I suppose, if it's not a problem. But in Brown, the court said if it hadn't been a 2-year sentence, if the court had simply imposed a normal length of contempt sentence, then the court would not have remanded it for more procedure. So we can look back now and say, well, gee, it would have been nice if Judge Kerr had given her more of an opportunity. It would have been nice if she had had more of a chance to speak. But the question is, what does the law require, and when does the judge act within his discretion? And the law doesn't require an opportunity to speak in summary contempt proceedings. Eaton didn't prohibit summary contempt in this context. In fact, if it had been loud and boisterous, Eaton suggests that this was exactly appropriate. And so if then we have all of the elements satisfied and they occur in front of the judge, he had the discretion. There was no abuse of discretion. And
Ms. Ray, was there
Sure.
a finding that the comments were, or the single expletive was, as you put it, loud and boisterous?
Absolutely. He said she shouted it in a loud and angry tone, and the entire courtroom could hear. And he said shouted, loud, and angry. I do want to quickly touch on what the relief should be should this court hold in favor of Ms. Oliphant, and say that it would not be appropriate to summarily reverse Judge Kerr's order. He should have the opportunity, if one of the suggestions is that he should have found to whom it was directed, if this court finds that legally matters, then he should have the opportunity to make that finding, having witnessed the conduct himself. And likewise, if this court finds that somehow it's not enough to reasonably infer the intent and he has to explicitly find it, then it should be remanded to give him the opportunity to
Sorry, what's the authority for that? I mean, it's a criminal trial, criminal hearing. It's supposed to be proof beyond a reasonable doubt. The finder of fact is supposed to make all of those findings in the first instance. You don't get a do-over in a criminal trial if, in a bench trial, for example, if a judge fails to find facts. So why would that be any different here?
I see that my time is up, Your Honor. May I?
You go right ahead.
Finish?
You go right ahead and answer, Ms. Ray.
Thank you, Judge King.
That and other questions you may get.
Oh, thank you, Your Honor. This is the question is so after you hold a hearing, you have then a written certification, and he did the written certification in the finding, and it would be appropriate for the court to remand and have him make additional findings. And I don't think that that's contrary to what a court would do in a bench trial if findings were inadequate, just as this court would do in a sentencing proceeding if the findings were inadequate, to go ahead and allow the judge a chance to make the findings. The judge was there, he found all the elements, but to supplement those with further explanation. Or perhaps to say, if based on what this court's opinion is, I don't make those findings. If Your Honors have no further questions, we respectfully request that the court affirm the judgment of the district court and the magistrate's contempt finding. Thank you.
Ms. Ray, do you think a lawyer should be treated more favorably than a mere civilian witness or visitor to a courtroom? I'm thinking the context.
No, Your Honor.
I'm thinking of in context of the Murillo case, where Murillo was a lawyer who was warned and was treated to a bench trial, not a summary proceeding.
Right.
And I'm thinking in the terms of the case I cited to your colleague there, Ms. Baldwin, the Nell case back in 1971, where Judge Hainsworth said, we're going to give him a trial or give a do-over, and it has to be before a different judge.
Your Honor, I'm not familiar with the Nell case, but with respect to Moriello, what I can say is that in Moriello, whether or not the court felt, first of all, that was an immigration judge, and it was actually different substantive question in terms of what the violation was. It wasn't a summary contempt proceeding.
But you're the one that brought it up. You brought it up. You cited it in your 28J letter.
I did, and if I may, I'd like to explain on what principle I cited Moriello, because it was not for whether or not, because it was too different of a proceeding for me to rely on much of that opinion. The only thing I was relying on in terms of Moriello was this court's recognition that when court personnel are distracted from whatever they're doing, whether that is continuing with a different, moving on to a different proceeding, or in the context of an immigration hearing, handling that immigration hearing, that's enough to constitute interference with the orderly administration of justice. And so if you look at the last page of Moriello, this court says, yes, even just the distraction that it provided the judge in that case, and Ms. Baldwin makes the point that the judge found that he heard and he was interrupted. Fair enough, but in this case, Judge Kerr himself heard and was interrupted from moving on to the next proceeding because he said, Marshall, go get her. And so we know that he was interrupted, and that my only point in Moriello was on that prong of the sufficiency of the evidence. Moriello supports the government's argument that the obstruction or the interference with the orderly administration of justice prong is satisfied. If your honors have no further questions, we request that the court uphold the contempt judgment in this case. Thank you.
Judge Diaz, Judge Floyd, any questions?
No, sir.
I don't think. Thank you.
Thank you very much, Ms. Ray. Ms. Baldwin?
Thank you, Your Honors. So I'd like to just start with a couple of corrections from what Ms. Ray stated. And first was the idea that the judge gave her an opportunity to speak in her defense. That didn't happen. The court's words were, quote, "So do you want to say anything before I impose a sentence?" That in no way gives her an opportunity to defend against the contempt adjudication he just issued. Second of all, the Brown case does support us. Ms. Ray points to the fact that there, the defendant was given the statutory maximum. But I would say Ms. Oliphant's sentence was more serious here because she was given 10 days, whereas Brown got 6 months on top of his 22-year sentence. Next, going on to, we have no case regarding loud profanity. We do. It's Brooks. It was cited in our briefs. The government never addressed it. And there, one of the parties said, fix some of the SHIT to the other party as he was leaving the courtroom, and the DC court reversed it. They found, listen, there weren't findings on intent. You can't assume they realized how loud it was or that the court would think it's discourteous when the case had recessed. Second of all, the In re Seal case that the DC Circuit addressed that's not here. We've already conceded that if the magistrate judge made the findings it was directed at the court, we wouldn't be making the arguments we're making here. And in that case, the judge found that the profanity was directly made at him in a calculated way. So again, not our case. Going on,
Ms. Baldwin, Ms. Ray would like, in the worst case scenario, I guess, for the government, it would like a do-over, would like the case to go back to allow Judge Kerr to make those findings. What's your position on that?
I'm not aware of authority for that position. I mean, the cases I've seen where the circuits have found the Rule 42 predicate deficient, they've reversed it. So I'm not aware of authority. The authorities I've found have reversed it, and I believe the Brooks DC case raised the fact that it would violate double jeopardy to do that. And second of all, as to the evidence to support the conviction, Ms. Ray speculates. Again, there were no findings. She claims there was a delay. The magistrate didn't find a delay. The record doesn't contain a delay. All the court said was, Marshall, bring her back here for the summary contempt adjudication. That is part and parcel of the contempt adjudication and cannot supply the obstruction element. Again, this is not a matter of simply misbehavior in a courtroom. Criminal contempt is for misbehavior that obstructs the administration of justice. So, which is not to say misbehavior is, allowed, because in egregious cases that, like, insulting a judge like the Marshall case, that's going to be enough in and of itself. And then the judge has the option of issuing rules to people like this is my code of conduct in my courtroom, and 18 USC 401 subsection 3 makes it contempt to violate a court command. So here we'd ask that the court reverse her conviction. I'm sorry. I wanted to address the loud or boisterous point. That is, we can see that the Supreme Court noted that the witness's statement did not attempt to interfere with the court, violate a court command, or was loud or boisterous. So we acknowledge that could distinguish the situation here, but it shouldn't. And that's because the same principle animating the holding in Eaton, that the single profanity wasn't enough to present an imminent threat to justice, it's the same case here. Perhaps a loud profanity said during giving jury instructions would present such an imminent threat to the administration of justice that would warrant making that distinguishment, but not in the case here. I see my time has expired, so thank you all for your time.
Thank you, Ms. Baldwin. We appreciate it. Appreciate the assistance of both fine lawyers. And if we were in Richmond, we would come down and shake your hands and congratulate you personally on doing a fine job. Maybe in the fall, we'll be able to do that. We'll take this case under advisement, Madam Clerk, and proceed to the next one.
Counsel, for the next case, please unmute your audio and your video.
Madam Clerk, we have both the lawyers now.
We have them both.
United States of America versus Lexi Lionel Herrera Pagoda.
And for Mr. Lexi or Herrera Pagoda, Ms. Gerges, if I pronounced your name correctly. If I haven't, I apologize. But it's good to have you with us.
Thank you so much. May it please the court. As Your Honor has indicated, my name is Nardine Gerges, and I represent Mr. Herrera Pagoda in this matter. He moves for an order vacating the order of dismissal on his motion to vacate under Section 28, United States Code, Section 2255, and remanding it back to the district court to vacate the underlying conviction or to remand it for further proceedings. Now, Mr. Herrera Pagoda, and I think from this point forward, I'll just refer to him as Mr. Herrera. Constitutional right to effective assistance of counsel was denied when he was not given a proper opportunity to legally defend against the charge of illegal reentry. And that was in the initial case, 715 CR 104. Had he been afforded such an opportunity in having effective assistance of counsel, he would not have pled guilty. Instead, he would have filed a motion to dismiss under Section 1326D of Title 8 of the United States Code. And what's really telling here is that part of the record, we have the affidavit from his former counsel identifying the deficiency in his representation, which I believe is very strong evidence to support the conclusion that this was the rendering of ineffective assistance of counsel. But for his former attorney's misapprehension of the law, Mr. Herrera would not have pled guilty, given that he was not guilty of this charge. This further excuses the fact that he filed his 2255 outside of the one-year window. Additionally, he did in fact file his motion to vacate as soon as humanly possible and should also receive the benefit of equitable tolling. He had no idea that this was in fact a possibility because he was under the misapprehension that was initiated from the 2010 proceeding. Now, the legal standard here that we need to kind of start off in discussing is illegal re-entry and voluntary departure. Those are the two concepts that are really kind of interplaying at the forefront, and then I'll venture into further details. In illegal reentry, section that is explained in section 1326A of the Title 8 of the United States Code. It makes it a crime for a deported or removed alien to attempt to enter, or be found in the United States without the express consent of the Attorney General. Because this prior deportation order, removal order, is an element of this crime, a non-citizen who was granted voluntary departure rather than deported cannot be prosecuted for illegal re-entry. Although the resulting effect is the same, that is with voluntary departure and in fact with the order of removal, it is distinguished for purposes associated with the underlying conviction of illegal re-entry. Voluntary departure is simply deficient in that sense, and it is considered a discretionary form of relief that allows certain individuals in removal proceedings, or as they commonly are referred to as aliens, either before the conclusion of removal proceedings or after being found ordered deportable to leave the country willingly. There's also another.
So, counsel, can I ask a question about that? So, with respect to this question of ineffective assistance of counsel and the requirement that you show that the proceeding, a reasonable probability of a different outcome with respect to the proceeding, if we're dealing with something that is entirely discretionary on the part of the immigration judge, then how can you possibly show that there would have been a reasonable probability that your client would have been entitled to that relief?
Due to the fact that on the record here, it is very clear that the immigration judge was actually proceeding in reviewing what could only be assumed to be the post-conviction voluntary departure, but we were at the time of the proceeding, we were pre-conclusion voluntary departure. And so it's very, and ironically, the post-conviction voluntary departure is a higher standard. It's a higher set of requirements than the pre-conclusion. And he was inclined, the immigration judge was actually inclined to provide Mr. Herrera with the ability to proceed with voluntary departure, although he doesn't specifically reference those words, but for the fact that he was here, and not just a reasonable probability in this case on the record that identifies that he would have in fact received the benefit of pre-conclusion voluntary departure, and certainly had the immigration judge ventured into further discussion the post-conviction voluntary departure as well. Does that answer your question, Your Honor?
Yes, it does. Thank you. So a related question is, if we're dealing with something that is entirely discretionary, this question of voluntary departure, and there's a requirement in order for you to obtain relief in this case that you show a violation of someone's due process rights, how is something that is entirely discretionary ever capable of sort of mushrooming into a due process violation?
Well, in the context of immigration proceedings, the majority of the forms of relief available happen to be discretionary. So although they're mandated by law, and there's a specific duty identified by the Board of Immigration Appeals for the immigration judges to be able to explain those discretionary forms of relief, I think it's exceptionally important in this case in particular that when you have a pro se defendant, your reliance on that immigration judge is high. It's extreme, because this is the means by which you receive a fair opportunity to be heard. Otherwise, if we don't permit the these so-called discretionary forms of relief to be proceeded upon or explained, that immigration proceedings become a mere formality by and large. And so I think when talking about it in the context of immigration proceedings, we have to recognize, by the grace of God, that this is a proceeding that highly is relatable, is highly connected to discretionary forms of relief.
Okay, thank you.
Now, moving forward, in regards to how we get to the point of attacking the illegal reentry conviction, it's a collateral attack. And interestingly enough, Mendoza-Lopez, which is a U.S. Supreme Court case, actually identified the means by which to proceed upon it, and then it got further codified thereafter by Congress under 1326D. And in order to be able to demonstrate the ability to proceed upon that, you have to show that you exhausted any administrative remedies that may have been available to seek relief against the order, and that the deportation proceedings at which the order was issued improperly deprive the alien of the opportunity for judicial review, and the entry of the order was fundamentally unfair. I'm going to start with
how do you talk about the third one of those extensively, but you don't deal with the first two?
So
how do you pass the first two?
Interestingly enough, it's an interplay. So the last prong, the fundamental unfairness, do in fact interplay with the third prong. And so if you take a look at exhaustion of the administrative remedies, Section 1326D1 requires that Mr. Herrera exhaust all of his remedies. But Mr. Herrera was informed that if he disagreed, and this is on the record, if he disagreed with the decision to order returning to Honduras, you have the right to appeal. Those were the quotes referenced by the immigration judge. His failure to exhaust should be excused because he did not make a knowing and intelligent waiver of his right to administrative review.
And he didn't seek an appeal.
That's correct. And the reason why is because he did not intelligently and knowingly waive his right to appeal. And so what happens here is you have an exchange between Mr. Herrera and the immigration judge. Clearly, the immigration judge is the authority in Mr. Herrera's eyes. And you have a circumstance where Mr. Herrera is looking to the immigration judge, and he's clearly indicating he wants to return. And the immigration judge seems to a certain extent, entertain that, but he incorrectly discusses that with Mr. Herrera. And then he concludes by saying, well, there's nothing else, there's no other forms of relief for you. And we are ordering you to return. And if you disagree with that, you have the right to appeal. So he says, no, that's fine. And that, in effect, waives his right to appeal, but it's not a knowing and intelligent waiver of his right to appeal.
So he can just hold those first two prongs in abeyance and bring them 2 years late in a habeas case.
But he wasn't in custody in a habeas. So that's the.
Well, you're attacking this conviction collaterally.
That's correct.
And you didn't deal in your brief with, I couldn't figure it, how did you get past the first two prongs to get to the, what you call the actual innocence argument?
Well, the way you get to it is.
So he was advised of his right of appeal and didn't do it.
He was advised of his right to appeal, but it wasn't an intelligent and knowing waiver of his right to appeal.
Right. He can put that in his pocket and do it later.
And so, in essence, what you have here is when he wasn't provided with the knowledge of not just how to appeal, but also the fact that there was nothing else for him to do.
I couldn't find in your brief how you even dealt with those first two prongs. And then I looked for your reply brief to how you responded to the government's brief, and you didn't even file a reply brief.
Well, Your Honor, I suppose I have to literally apologize for that. And simply speaking,
No, well, maybe, which indicates to me you didn't have an argument to make against him.
well, I believe that due to the so what I looked at was the fundamental unfairness. And given the fact that he did not know what was going on because he was misinformed, that goes hand in hand with the non-intelligent and non-knowing waiver. And so that's the way I saw it in regards to it going hand in hand with that particular requirement. And to move forward to the judicial review, and certainly we discussed Mendoza-Lopez, as stated in United States v. Mendoza-Lopez, an unknowing and unintelligent waiver of the right to appeal denies non-citizens of judicial review. So if you take a look at the third prong, which is the fundamental unfairness, it really does tie these last two prongs. And perhaps that's the reason why I didn't venture into those last two prongs, but I certainly don't want my error in being non-descriptive enough to come back to haunt Mr. Herrera-Paguada. And that is the reason why I want to make very clear that those two prongs are important, but they go hand in hand with the fundamental unfairness. And in essence, when you take a look at those two prongs and you discuss thereafter the fundamental unfairness, which was what I was going to discuss initially, but I certainly wanted to make sure that I addressed any and all questions. The fundamental unfairness here is due to the fact that we have a due process violation, and then second, we have prejudice. And the due process violation is clearly noted in the record, the recording that we submitted as part of the joint appendix. On that particular recording, it is evident that the immigration judge clearly misadvises Mr. Herrera. And even though he doesn't even specifically venture into the discussion of the words voluntary departure, it seems as if he's aligning himself with the second part, which is the post-conviction voluntary departure. And like I indicated earlier, that's a higher standard. And being that it is a higher standard, it would reasonably follow that he qualified clearly for the lower standard one, which is the pre-conclusion voluntary departure.
Counsel, can I ask a question about back to fundamental unfairness? Do we need to find a due process violation, or simply is it enough that the petitioner in this case simply wasn't informed of what I think we all agree was a discretionary avenue of relief for the immigration judge? But there's a distinction, right, between finding voluntary departure to be a due process, a substantive due process right, and just simply failing to inform a petitioner of a right, whether it amounts to a due process right or is entirely discretionary. So what's your position? Do we need to find that it's a due process right, or is it enough to simply say that because he was not informed of this right, whether it amounts to a due process violation or not, that doesn't matter?
I believe they're interchangeable in this context. And so what I see as him being misinformed and also not being informed, because he wasn't informed. And I noticed that my time is up. Can I have the opportunity to respond to your question?
You can finish your answer there and answer any other questions you get. Go ahead.
Perfect. Thank you, Your Honor. In this context specifically, you have a circumstance where he wasn't properly advised of the pre-conclusion voluntary departure, and he was misadvised of the post-conclusion voluntary departure. And so it is apparent on its face that these two would have very appropriately met as a form of relief for him, even though the form of relief is discretionary. And I want to make sure that we understand, despite the fact that it's discretionary, it still can rise to the due process violation and certainly meet the unfairness prong, so long as he was also prejudiced. And the reason why is because it is mandated by law. And when the regulations themselves also bestow upon these immigration judges the duty to inform respondents in immigration court of these forms of relief. And when we are looking at administrative agency, if they've identified certain duties for their individual players within that administrative agency, I believe we have to respect that and recognize that that is in fact what makes that proceeding, you know, fundamentally fair. And when those duties are materially abridged, in essence, therein lies the fundamental unfairness, the due process violation. And with prejudice, clearly on the record, it's hard to even imagine how he wouldn't have qualified for pre-conclusion voluntary departure at the very least. And so you do meet that third prong. Are there any more
Thank you
questions?
very much.
My pleasure.
Gerges, and Mr. Duffy, you out there?
Yes, Your Honor.
Good to have you with us.
Thank you. May it please the court. My name is Dennis Duffy, and I represent the United States in this matter. Your Honors, this case involves an ineffective assistance claim, which was properly dismissed by the district court on 3 independent grounds and should be affirmed by this court. At the outset, it's crucial to keep in mind that the resolution of this case should be based on the application of 2255 case law. This case does not involve a direct appeal from a Board of the Immigration Appeals administrative determination. We're several steps removed from that. Likewise, this is not an appeal of a district court's ruling on a 1326D affirmative defense. Instead, Your Honor, this is simply an ineffective assistance claim and must be viewed in that context. And as with any 2255 case, there is always going to be a little bit of attention between the finality of the judgment and the need to provide a criminal defendant with some sort of an avenue for relief when a constitutional error is of the type and dimension that simply is not present here. Because we are in this 2255 context, it's the government's position that the appellant has a much heavier lift as far as what he needs to establish to get relief. And what I mean by that is, unlike the other 2 procedural postures I explained, the appeal from a BIA opinion or a direct appeal of a district court's denial or affirmation of an affirmative defense, in this case, he has the burden of going through Strickland and proving those elements. And we do not believe he is able to do that. In addition, he has to go through the exceptions and establish that he is an exception to the statute of limitations and also the procedural default. And again, we do not feel that he has the ability to do that based on the facts. Now, Your Honor, with regard to Strickland and the prejudice prong is what Judge Howard held that and was one of the 3 bases for dismissing the 2255 claim. And with regard to prejudice, Mr. Herrera has to show by reasonable probability that but for counsel's unprofessional conduct, and that would assume that there is unprofessional conduct, which we don't think there was, the result of the proceeding would have been different. In this particular case, he cannot show that. I do not believe in the record he has shown or fulfilled his burden of showing that he would not have pled guilty, would have pursued a 1326D defense, and there would have been some likelihood of success. I don't think that's shown in the record. Now, with regard to defense counsel Jay Todd's affidavit, I believe Ms. Gerges referenced that. If you look at that affidavit, it simply indicates that he might have raised a defense. He doesn't cite applicable case law relating to the issue of whether there's a due process violation when you don't give notice of discretionary relief. He cites 2 cases that simply refer to the ability to challenge removal when it's done by way of reinstating an earlier deportation order. In essence, the government's position would be that Mr. Todd's affidavit doesn't show anything as far as ineffective assistance or prejudice. It simply shows that based on a Ninth Circuit law, it might have been worth bringing this in Ninth Circuit. It was not brought here in the Eastern District of North Carolina, and in this case, it would have been a much heavier lift in the sense that, unlike the Ninth Circuit, the Fourth Circuit has held that there is no due process right to a discretionary relief. And then the next step, and what hasn't been ruled on by the Fourth Circuit, is whether you have notification or a due process right for notification of a discretionary relief, which we argue is not the case, and most circuits follow that argument. As a result, Your Honor, we think it's a fairly heavy lift for Mr. Herrera to be able to establish on the record that he would have raised this if he knew about it and that he would have won on it. Instead, he pled guilty. He faced a guideline range of 10 to 16 months, and he got 11 months. Had he decided to move forward and go to trial, there's a possibility he would have gotten more time. He might have lost his 2 points of acceptance, and that would have upped it to 15 to 20 months. So at the end of the day, Your Honor, we don't think that Mr. Herrera can show that he was prejudiced by this decision not to raise a defense that we think he would have lost. And again, this is his burden. He has to show in the context of the 2255 a reasonable probability that but for counsel's unprofessional conduct, that the result would have been different. And again, in the context of a plea, you can't just say I would not have pled guilty. You have to show some basis to the fact that you would have in fact pleaded not guilty. And under the Supreme Court's ruling in Hill versus Lockhart, you have to show some likelihood of success. We don't believe he has that success here, that he would have been able to show under 1326D that he would have been successful. So that sort of, we're still in 2255 land, and the prejudice definition for that is slightly different than the prejudice definition under the third prong of 1326D. But it's our position that he does not meet that prejudice standard. Doesn't even come close. And Your Honor, with regard to, even if he gets somehow past that, even to get to that, he still has to show he somehow should be excused for an untimely filing of the 2255 and for procedurally defaulting it by not raising it on direct appeal. And again, with regard to each of these, is an exception if he can show actual innocence. But in order to show actual innocence, he has to show more likely than not that no reasonable jury would have convicted him. Now, in this context, it's a little different because it would have been an affirmative defense that probably would have been resolved by Judge Howard on a motion, but he still has the burden to show more likely than not he would have been able to win under that affirmative defense. So as a result of that, Your Honor, we think 2255 should resolve this case, and the court need not go below and get into the definition of whether the right to be given notification of a discretionary right is somehow a due process right. Now, with regard to, Your Honor, if you do go into that area and we do look at the 1326D3 issue, obviously there's three prongs that Mr. Herrera would have to meet, and it's the government's position he does not meet any of those prongs. And we can start with the third prong. Even if you don't get into this, split of the circuits regarding whether a person, a non-citizen in a removal hearing can have a due process right to have notice of the potential to get discretionary relief, of which he has no due process right to. Even if we skip that for the moment, under that fundamental unfairness, he can't show prejudice. And Judge Diaz, you asked the question, and I think it's a fair question, under 2255, how can you show reasonable probability of a different outcome if it's a discretionary right he's trying to ask for? It's speculative at best as to whether he would have gotten it. And if you look at an unpublished case that Judge Motz, I think, was part of, it's United States versus Showmaid from 1997, it talks exactly about this, and it specifically references the fact that it's speculative at best as to whether he might have gotten the discretionary right.
Mr. Duffy, can I ask about that? So in response, your opponent on the other side indicated that the tenor of the hearing before the immigration judge seemed to suggest that he was inclined to grant some kind of departure relief, but for the fact that the petitioner didn't have the money to comply with voluntary departure. Is that enough to sort of get beyond the speculative realm that we're in?
No, Your Honor. First of all, the government disagrees that the tenor of this hearing can somehow be interpreted that the judge was likely to grant voluntary departure, whether it was pre-conclusion or post-conclusion. I mean, we had a case involving a non-citizen at a deportation hearing who had been charged with a felony drug case, felony trafficking by possession of cocaine, 200 to 400 grams of powder cocaine. The immigration judge knew enough about it to directly ask, well, what's the deal with this? And Mr. Herrera stated, oh, I showed up and I'm not guilty. Well, that was not true. Now, whether he knew it wasn't true when he said it or he was confused, it's unclear. But what was clear is the immigration judge was concerned enough about the fact that he had a drug conviction out there to say to the Mr. Herrera, even if you were found innocent, it might have an impact on your ability to come back. We also have an applicant that would have 3 DUIs. We also have an applicant that has said, I don't have the money to come back. And that was one of the factors that's looked at when the judge, remember, in this situation, once it gets to the immigration judge's discretion, it's pretty wide open as to what he can review, as long as it's not abuse of discretion. And I think based on simply the facts within the 4 corners of that hearing, we've got a drug charge, which the judge probably would have dug into to look. And again, this is speculative because the burden is on Mr. Herrera to show that he would have gotten this discretionary relief. And I think simply from what's in the 4 corners of that hearing, he can't prove it. It's not a matter of not proving it. I think it was unlikely he would have been granted this relief based on the fact that he had an outstanding drug charge, he had absconded, he had 3 DUIs. And the only thing that wasn't in the record yet is the fact that he had absconded. But the judge was sure enough to look at it, and we don't know what would have happened. The judge might have continued it to another master hearing date and then dug into that criminal charge to determine. So based on that, Your Honor, we don't think he can come anywhere close to proving that he would have been granted this. If anything, the record shows the opposite. Now, with respect to the due process right, Your Honor, that's obviously, it's a well-briefed area, not only this case, but many others. But again, we don't think the court needs to get there because we're in the context of a 2255. Obviously, we have, the Fourth Circuit has not specifically ruled on the notice issue, but they have ruled on whether you have a constitutional right to a discretionary relief. I don't think there's any dispute in this case. And when we go
how does that circuit split stand?
Your Honor, my understanding on the circuit split is, with regard to the notice, is we have 5 circuits that rule that there is no due process right to notice, and we've noted them in our brief: the 3rd, the 5th, the 6th, the 7th, and the 10th. And then you have 2 circuits that seem to argue that due process right, you do have a due process right to notice. And why I say seem to is in the 9th Circuit, there are clearly 2 cases that say that. The 2nd Circuit is a little confusion. That's that Copeland case, because in the 2nd Circuit, they have held, unlike this court, which held under Wilson, that fundamental fairness prong, the first part of it is a constitutional due process right violation. In Copeland, in the 2nd Circuit, they held it doesn't have to be a due process constitutional violation. So I don't know if Copeland's completely on point with them, but the 9th Circuit does go their way. And candidly, there are some district court cases within the circuit which also go that way. And there's also district court cases that go our way, which I think is why Judge Howard certified it for appeal. Now, with respect to the first 2 prongs, the exhaustion of and then this 3rd prong, which is improperly being deprived of an opportunity for judicial review. On the exhaustion of administrative remedies, Your Honor, we believe that is shown by the record. He was given the right to appeal, and he waived it. This judge went to a lot of trouble explaining other rights that were more directly involved. The fact that he could apply again for temporary protective status. Then he got into the fact that he could apply for non-LPR cancellation because he had 2 children while in the United States. And the judge went as far as to say, I can give you a list of attorneys you might be able to get, and we can continue the hearing. And Mr. Herrera made it very clear, no, I don't want to do any of that. I just want to leave, in which he was deported. But the other issue, Your Honor, with regard to exhausting administrative remedies, he came back twice, and there were 2 more removal hearings before this criminal case in our district. And at both of those removal hearings, it was a reinstatement use of the original order as they're allowed to do under Title VIII. And in either one of those, he could have raised this issue again, and there was an opportunity to challenge the original deportation order. Now, there's nothing in the record as to whether he challenged that. The only thing in the record is he was deported based on the reinstatement of the 2010 order. So as a result of that, Your Honor, we think he hasn't met the burden of showing these exhausted remedies. And with regard to the second prong, which is that he was improperly deprived of the opportunity for judicial review, we don't think that was the case here at all. We think he was told you have the right to appeal. This is not a case that's similar to, well, it's not a case that falls into any of the categories in Ross v. Blake, that Supreme Court case that talks about different ways that judicial review can be blocked, essentially. We don't have a situation here where he was basically, there was some administrative scheme afoot to trick him into not applying. And this was the reason that Ross v. Blake is relevant to the prong 1 and 2. That was the reason in my Rule 28 letter I referred you to last week's Supreme Court argument, because it did deal to some extent with Ross v. Blake. It's not immediately, it's somewhat distinguishable on the facts, but the Supreme Court did seem like it might rule or might give some more guidance on Ross v. Blake, which has some impact on prong 2. As a result of that,
if we could decide this case on prong 2, would the constitutional avoidance doctrine kick in on dealing with prong 3?
Your Honor, I don't think it would, because on prong 3, I mean, you still have to show prejudice. And if your argument, I mean, you're still, and under the prejudice, the definition for purposes of fundamental unfairness, it's a little bit different than the Strickland.
No, but there's an and in those three prongs. It's yet they have to win on all three of them.
That's absolutely right, Your Honor. They have to win
well,
all three.
If he loses on the second one, why would we have to decide a constitutional question?
You don't need to. You're correct, Your Honor. You don't need to decide.
I mean, that goes back to the old Ashwander case in the 30s or 40s.
Right, and again, I think it goes even a step further back, because I think you can avoid even ruling on that by just simply ruling on the 2255, because Judge Howard ruled on prejudice, but I don't think there's a performance issue here as well. Now, candidly, we raised that, and the judge didn't rule on it, but I think if you look at the state of the case law regarding whether he could have won under 1326D3 in our district, I don't think he would have. So I don't think.
Mr. Duffy, can I ask a question about a waiver of judicial review? And I'm not faulting the immigration judge in this case, because I do think he was trying to be solicitous of this particular petitioner. But we have cases in our circuit that talk about a waiver. In order for a waiver to be effective, that a petitioner or defendant has to understand the full significance of what it is that he or she is waiving. And how can we say that that's true here when he wasn't fully advised of the full sort of range of voluntary departure remedies that were available to him?
Well, Your Honor, if we go down that road, there are so many discretionary types of relief under the immigration laws. And I'm not an immigration attorney. It seems like I've become one in the last month by reading up on this case, but there are so
You say that with great glee.
Well, this will be it for me, I hope. But it's a very complicated area, obviously. I've learned a lot. I've learned that there's pre-conclusion and post-conclusion voluntary departure. I've listened to a lot of arguments, and what I've come to know here is if an immigration judge has to give full notice of all potential discretionary relief in a way that's understandable, then I don't know where it ends, because instead of a short removal hearing, you're going to start to have mini trials, in the sense that the judge is going to have to go through all these potential things. So I think it comes down to the fact that this is not a due process right that he's not being told about. This isn't a situation where the judge didn't tell him he had a right to appeal and left that out. This is notice of something that's completely discretionary. So I guess the response would be the fact that the notice was of something that's completely discretionary, even though it was in error. It should have been told. It's not enough to basically invalidate the entire deportation order for purposes of the criminal statute.
That sounds like a sort of an argument that it's good enough for government work, which I don't
Well,
think you're intending to say.
I wouldn't go that far, but I think given the way Congress wrote 1326, the decision on the first element to just say there is a deportation order and you were deported pursuant to a removal deportation order and you chose to come back illegally knowing that you were deported. Therefore, the question becomes is when we have a criminal statute that Congress decided to have the first element not be that the government has to prove validity of the order. That's why they had 1326D to be that narrow exception where they can challenge the order. If we get to the point where they can basically knock out 1326D by claiming, well, he didn't give notice of this, he didn't give notice of that, then it's almost like we're changing the first element of 1326. So I'm mindful with regard to the immigration cases and the Supreme Court, some of the recent decisions by the Supreme Court. It's obviously a very confusing area, for example, with the notices of these hearings, which, but that's not what we have here. This is a little cleaner. And again, we're not only we're 3 steps removed from that hearing. Your Honor, I see my time is up. If you allow me to proceed.
You may answer any questions that the judges have, certainly.
Did that answer the question? Or that would be our position, Judge Diaz.
I appreciate that. Thank you. I don't have any further questions.
Anything further, Judge Floyd?
No, sir.
Thank you very much, Mr. Duffy.
Thanks, Judge King.
Ms. Girgis?
You're muted, Ms. Girgis.
Yes, I realized that something came up. Can you all hear me now? All right. Thank you so very much for pointing that out, Judge Diaz. And so I wanted to make sure to address this very important point regarding the fact that on the proceedings themselves, it is very clear that he qualifies for voluntary departure, both the more stringent one, which is the post-conclusion one, and the pre-conclusion one. He had no aggravated felonies. And there are a series of equities that the immigration judge actually goes into. He had been there for 10 years. He had no criminal convictions. He, in essence, also had 2 United States citizen children. He had been gainfully employed during those 10 years, and he was paying taxes during that time. And so there's very little room to even assume that he somehow did not qualify for voluntary departure. As a matter of fact, voluntary departure is an actual advisal that, at least in every proceeding I've been in, I've heard the immigration judge say. And it seemed as if this particular immigration judge was trying to remember it and couldn't quite figure it out. He even asked the government 2 times, is he missing any other form of relief? As if it was on the on the tip of his tongue, but he just couldn't recall it. And the reason why the immigration judge actually was discussing coming back is because with an order of removal, you have a 10-year bar. And he had 2 United States citizen children, which means he could have, in essence, obtained a certain citizenship down the line through them. But in essence, if he had that order of removal, then he would have had the 10-year bar. With a voluntary departure, you can actually proceed through consular processing. And that in part, I would imagine, if he's connecting the dots with respect to the law, is the reason why he was discussing this issue regarding coming back. And so I think it is very noteworthy to identify that he, without doubt, actually qualified for voluntary departure. And but for the serious error of what voluntary departure is and the fact that it had it has 3 separate forms, the immigration judge would have in fact granted it. He was even talking about non-cancellation of removal, which clearly, if you qualify for that, you most certainly qualify for voluntary departure. The uniqueness of this discretionary form of relief, and I don't think that this should be something that is just overlooked, is that you get the return. And in essence, therefore, the alien is no longer present in the United States. So where it becomes important is that it actually will permit the alien to come back if he in fact had relative United States citizen children or direct relatives, which in essence is what we have here. And I imagine that's the reason why, part and parcel, is why the immigration judge was trying to venture into it, but just didn't do it appropriately. And you don't have to, I don't believe we need to reach the issue of whether or not we need to address every single discretionary form of relief. I think when it is apparent on the record that an individual who is in removal proceedings, that is an alien, does qualify, especially if that individual is a pro se individual, for a particular form of relief, then yes, there is a duty, a very serious and important duty to ensure that this particular proceeding is fair, to inform the respondent alien of that particular form of relief. And it would appear that that is what the immigration judge attempted, but yet failed, and sadly, egregiously failed in doing. And as such, that's the reason why we are currently here. It's due to the fact that had the immigration judge, in fact, done it the right way, since Mr. Herrera desired to return, he would have been able to proceed on voluntary departure and, in essence, gone through consular processing to come back to his children. I see I am out of time. I would just leave with this last remark. I think it is important to ensure, if your honors would permit me, I just have one more thought.
Go ahead.
Okay, thank you, Judge King. I think it's very important to note that whenever we're reviewing a proceeding, especially an administrative proceeding, we look to what, in fact, makes that proceeding fair. And in this case, it is already identified by the Board of Immigration Appeals what specifically, and the regulations, that the duties to apprise certain respondents like Mr. Herrera Paguada of the apparent forms of relief that are available to them is the cornerstone of fairness with respect to this proceeding. Thank you, Your Honors. And if you have any questions, I would love to answer them.
Thank you, Ms. Gerges. We really appreciate it. And I note that you were appointed by the court to represent your client, and we appreciate your service.
Thank you so very much, Judge.
To your client and to the judicial system. And we thank you very much. We couldn't function without lawyers like you.
Thank you so much.
If we were in Richmond, we would come leave the bench and greet each of you. And we'll have to defer that to your next visit to the Fourth Circuit, hopefully, when we can do that. Madam Clerk, the business of the panel being complete for the day, we can adjourn until tomorrow morning, I assume.
The Honorable Court stands adjourned until tomorrow morning. God save the United States and this Honorable Court.